Good day. My name is Martin Schweiger and I'm a patent attorney. I work internationally and I'm one of 5,000 FICPI members, one of the largest organizations for IP professionals in this world. Today I wanted to give you more information about the role and value of a patent attorney in protecting intellectual property. Let's now look into how protecting intellectual property rights can drive business growth, because intellectual property rights are a big part of innovation. The first big statement here is that protecting your intellectual property assets adds value and helps to grow your business. And there's nothing that has not been examined by science, and there's a 2019 study produced jointly by the European Patent Office, EPO, and the European Union Intellectual Property Office, EU IPO, that found that small and medium-sized businesses which have filed at least one intellectual property right are 21% more likely to experience high growth afterwards, compared with similar firms without any intellectual property rights application in place. That's quite an important intermediate result. You can see the full study here at the EPO news. I've put the bit.ly link so that you can more easily find the source for this statement. So what you could think here is that just by filing any intellectual property right would promote you on a growth path. However, the processes to apply for, and I must emphasize here, to be granted protection for your intellectual property assets are varied, often complex and difficult to obtain. In the first place, the application process can be lengthy. Then, without the help of a specialist patent attorney, you are likely to find yourself spending far too much of your valuable time on the application, and you may never complete the process. Because even if you do complete the process, you might find that your hard-won IP rights are worthless because, for example, they are too narrow or too specific. And this is your introduction to the value and role of a patent attorney. Let's look at the role of the patent attorney. In the first place, intellectual property attorneys, such patent and trademark attorneys, take you every step of the way through the application process. In addition, they help to identify and deliver the most value from your IP protection. Also, if anyone infringes your protected IP, your patent attorney will help enforce your legal ownership and seek compensation. Here are some of the areas of expertise provided by a patent attorney. We patent attorneys provide IP protection, especially for patents, trademarks, copyrights, and also of trade secrets. We draft patent and trademark applications. We prepare the legal filings of those. Then we settle IP disputes. We manage IP assets that can be very valuable for your company. We identify IP rights that are held by others. That's important because we need to find out whether you have a freedom to operate your business in view of these IP rights. Then we deal with licensing. That means you can derive income from your invention by licensing to others. Then we do asset transfers, if you sell your IP, for example, or if you purchase one. Then we also work with valuations to find out what is the real value of your IP right so that you can take it up into your balance sheet. And also we deal with IP ownership issues, as they often arise between employees and employers. Let's now talk about how the benefits of a patent attorney earn the investment into a patent application. The first and foremost advantage of having a patent attorney helping you with your patent prosecution is that you are much more likely to complete the application process. There will be much more to be said about that at a later time. Then also, you are faster and also more efficient in doing so, which means that you get your patents much earlier than doing them yourselves. Then it's easier to overcome objections of the patent office, which there are usually a lot, and also make sure that the granted rights are effective in scope, because a patent that is not effective doesn't help you. You have spent all the money in vain. Of course, there's also research done into how the patent attorney adds value to the process of innovation, and this was commissioned in 2013 by my organization, the FICPI, FICPI, the Trusted Global Community for Independent Patent Attorneys. By the way, we have over 5,000 members, so it's always good to have one of those patent attorneys helping you. That research is called the Heusel-Wagner report, looked more closely at the work of the European Patent Office. And in the following, I will present you what is the outcome of the Heusel-Wagner report. In the first place, the authors discovered that applicants that are not represented by a patent attorney are much more likely to lose rights simply by failing to understand the procedure or that a response is required. I find that quite amazing, because to me it looks like self-evident that you have to reply to a patent office communication when it comes up. The Heusel-Wagner report was commissioned as a part of a wider study by FICPI into the value added by IP practitioners to the innovation process. This is known as the Project Orange, after the name of the chairman, John Orange. You can download a brochure with fuller details of Project Orange's findings here, and I put the bit.ly linked bit.ly/IP-practitioner, and then you can download it from there. And here are the reasons why IP applications are more successful with the support of a patent attorney. The 2013 Heusel-Wagner report, which closely examined the workings of the European Patent Office (EPO), found that small corporate applicants rely on an independent patent attorneys more frequently than their larger counterparts. It is also found that applications that were represented by independent patent attorneys are granted at a much higher rate than filings with no professional representation at all. In addition, the patent application filed by an attorney is more likely to withstand opposition and challenges from competitors. As you know, a granted patent is not carved in stone, so after grant it can undergo some challenges, and having professional help for those is something that increases your chances of success tremendously. The Heusel-Wagner report also discovered that applications which had no professional representation at all are much more likely to be withdrawn during the process. These withdrawals happen right after the expensive filing fee had already been paid, and you will not get this fee reimbursed if you abandon your patent application. Many patent applications were withdrawn because the applicant did not respond to a correspondence from EPO. And in fact, of 50 such applicants in the study, only 19, which is only a mere 40%, were still active for the payment of the first renewal fees at the first year. That means that 60% of the self-made patent applications were dropped before the expiry of the second patent year. In the following, I wanted to show you 10 ways where an intellectual property attorney adds value to your intellectual property. In the first place, protecting your intellectual assets adds value and helps to grow your business. That's often overlooked. So the patents are not only a help in promoting your own business over your competition, but it also adds value that can be measured. The 10 ways that independent patent attorneys create that confidence and add expertise to the procurement of IP rights are as follows. First, the patent attorney helps you to identify the IP rights that potentially exist and can be protected. That's not obvious in the first place. Second, patent attorneys are familiar with a wide range of technologies because in their daily work they are not only confronted with one single range of technologies because they have more clients than one, but they have a wide range of technologies. And so it is very easy for them to identify synergies between other ranges of technologies and your own technology. Next, patent attorneys have an ability to describe and clearly define your innovation, and that's very important if you want to patent it. Patent attorneys are also trained to skillfully draft your patent application with appropriate breadth for the best protection. That's why we have to study between 3 and 5 years, and many of us have many more years of practice in doing so. Then, patent attorneys understand new technology to differentiate the innovation and extrapolate the potential future use. That is important to increase the value of your IP. Then, patent attorneys describe the innovation, hopefully, in a manner that is readily understood. That's also a good way to test your patent attorney. If you cannot understand what he is describing, then probably you're not with the right patent attorney. 7. Patent attorneys understand the legal balance of protecting the innovation while advancing the wider public interest of advancing economic development. It is very important to understand that, because a patent undergoes a grant process, and as a patent applicant you're in a constant battle to get a wider protection, while the patent office is there to balance that out with the public interest. Patent attorneys are also trained to balance the basic needs of the IP system with obtaining the protection to which the innovator is entitled. That goes very deep to the roots of patents, why there are patents, and how it works to get a patent from the government, which is, in other words, a monopoly that you can use against your competition. Patent attorneys are also trained to anticipate objections and infringements in other countries and regions. That's why we have an international network, and we undergo constant training where we learn about patent infringements overseas. And of course, patent attorneys are trained for knowing how to avoid the IP rights that are held by others, so that you have a freedom to operate in your own business. Let's now come to a few frequently asked questions when it comes to inventions. Question number 1. Is it true that good ideas are stolen or copied? And the clear answer is, some of the most famous inventions in history were based on stolen ideas. For example, the invention of the sewing machine is commonly attributed to Isaac Singer and the Singer corporations. But in fact, the design was originally patented by an inventor called Elias Howe, and following legal action, Singer was forced to pool its patents and share the royalties with Howe. Ironically, a gentleman called Walter Hunt had, even earlier, invented a sewing machine, but he did not patent it. You can read an article, 10 Great Business Ideas that were actually stolen, and the link is here, bit.ly stolen inventions, and then you can download it from there. Next, are counterfeits from China a problem for small businesses? I hear that often, and working in Asia, Singapore to be more exactly, and I'm often in China, and I can tell you today China has a very effective legal system to deal with the problem of IP protection. That may have been different in the past, but today China is one of the countries that is leading in the area of IP protection. And that is not only for registering IPs, but also for enforcing them in court. China has made the biggest leap of all the countries that I'm aware of in this respect. So today, China is Premier League when it is about IP protection. The problem is that this IP protection system is only effective if you applied for IP protection in the first place. Should be clear, right? But people often forget that. Look at the story of Ruth Bronze. She's a violin teacher in the US, and she invented an accessory to help students to hold the bow correctly. Ruth acquired the trademark Bow Hold Buddies, and she patented her invention in the US, in Canada, in Mexico, in Europe, even in Australia, but not in China. And now, when she planned to move to the China market, she discovered 2 factories that are already making counterfeit versions of her product, selling at a fraction of her price. You can read the full story of Ruth Bronze's expensive struggle to regain protection for her product in China here. bit.ly/counterfeits China. And then people often ask me, what is FICPI and how can it help small businesses protect their intellectual property? So, FICPI is the trusted global community of independent patent attorneys, trademark attorneys and lawyers that specialize in intellectual property in private practice. FICPI is an acronym, and it stands for the French term Fédération Internationale des Conseils en Propriété Industrielle. It's International Association of IP Attorneys in the area of intellectual property. FICPI members know how to navigate the world of intellectual property, and they assist small businesses in IP protection, drafting of applications, prepare legal filings, settlement of IP disputes, managing IP assets, licensing, asset transfers, valuations, and IP ownership issues. You can find a trusted IP attorney in your country or region by searching on our FICPI website, ficpi.org/member-search.